Hi, and welcome to Chapter 10. So this week we're going to be talking about workplace legalities. So let's start discussing employment at will. You may have heard this term before because Pennsylvania is a state where they have this concept of at will employment. So this means that either the employer or the employee can end the employment at any time for any reason. There is a little asterisk there because it has to be a legal reason. You can't fire someone based on gender or their nationality, their age, things like that, which we'll talk about a little bit more in a little bit. But any other reason they can be fired, or the employee can actually quit as well for any reason, and the employer cannot take any legal action or consequences against that employee. There are a few factors that affect employment at will, including some different federal and state statutes, executive orders, case laws. If there's a specific contract between a worker and the employer, it may prevent this at will quitting or firing. Collective bargaining agreements between companies and unions, and then also civil service rules for government workers. They might not be able to follow this concept of at will firing or quitting. So let's talk a little bit more about hiring and firing. Generally, an employee cannot sue their employers because they have been fired, as long as it was legally done. But an employer cannot fire an employee for an illegal reason either. There is such thing as wrongful discharge, where the employer does risk getting sued if there is no just cause, legal reason for firing an employee. But typically that has to be a state that doesn't have at-will employment. So usually this doesn't apply to Pennsylvania because we are an at-will state, and as long as it was a legal reason that they were fired, the employee cannot sue them. Public policy. So this is a common law concept of wrongful discharge when an employee has acted for the common good. So they may have did something that may have been viewed bad by the employer and the employer fires them, but what the employee was trying to do was actually benefiting someone or trying to help someone out. So this would be like refusal to committing an illegal act. If the company you work for asks you to do something illegal and you're like, oh, I don't know, that goes against my morals, I'm not going to do that, the employer can't take action against you for choosing not to do something illegal. Whistleblowing, and then performing a legal duty. If it's legal and you do it, the employer can't fire you for doing that. And then exercising a private right as well. But again, this kind of goes back to if the state is an at-will employment state, or if it's one of the states that are not. Protection from discrimination. So there are federal laws that forbid discrimination when it comes to any aspect of employment. Race, color, religion, national origin, whether you're male, female, transgender, you have rights as an employee to not be discriminated against. Your age, being over the age of 40, having a disability or a history of a disability, particular genetic dispositions, pregnancy, being in a union, or even engaging in political activity is under this discrimination. So conditions for sexual harassment. There's kind of three areas here where it counts as sexual harassment. The first two, essentially getting hired on terms of sexual conduct, where you may be given the job if you do specific favors. The second one is either engaging in sexual favors for like a bargaining tool, like if you do this for me, I'll do this for you, or even if you're penalized for rejecting a sexual act, that is sexual harassment as well. And then the third version is when the sexual act or conduct has it's interfering with your work performance or just creating a negative environment to work in. So there are quite a few federal labor and employment laws from the last century. So the Wagner Act of 1935, this makes it illegal to discriminate in hiring or firing because of union membership or organizational activities. We have the Civil Rights Act of 1964. This deals with discrimination based on race, color, religion, sex, nationality, but only if the business has more than 15 employees. That's the key term there. If it has less, they unfortunately don't fall under these laws, and you'll see ahead here that there are quite a few of these laws that you have to have over a certain amount of people for them to actually be a law. The Civil Rights Act of 1964 also prevents federal judges from using affirmative action, which are programs that use goals or quotas to provide preferential treatment for minorities. So these judges aren't allowed to give minorities special treatment just to hit their quotas or goals. We have the Age Discrimination in Employment Act of 1967. So this prohibits discrimination in hiring or firing of those over the age of 40 if the business has more than 20 employees. We also have the Rehabilitation Act of 1973. This prohibits discrimination in employment practices based on physical disabilities or mental health. Next, we have the Pregnancy Discrimination Act of 1976, which makes it illegal to fire an employee based on pregnancy, childbirth, or related medical conditions. We also have the Americans with Disabilities Act of 1990, which bans discrimination against those with disabilities if the business has more than 15 employees. There's also the Civil Rights Act of 1991, which provides benefits for employees who are able to prove that they were discriminated against. And we have Genetic Information Non-Discrimination Act of 2008, which prohibits discrimination in health insurance and employment based on genetic information. And last, the Lilly Ledbetter Fair Pay Act of 2009. It just has some revised sections of various acts listed above regarding statutes of limitations and the recovery of back pay. So, federal labor and employment laws. We do have some wage and hour laws. The Social Security Act of 1935 covers Medicare, disability insurance, and unemployment insurance. Fair Labor Standards Act of 1938 prohibits child labor and provides for overtime pay and a minimum wage to be in effect. We have the Equal Pay Act of 1963, which requires equal pay for men and women who are doing equal work. And then the Employee Retirement Income Security Act of 1974, which regulates private pension funds and employer benefit programs. We also have some work safety laws. I'm sure most of you are familiar with OSHA, which is the Occupational Safety and Health Act of 1970. So this ensures safety of workers and prohibits firing an employee if they report workplace safety violations or hazards. And then some other terms of employment. I'm sure you've heard of FMLA, which is the Family Medical Leave Act from 1991. It mandates allowing employees to take unpaid leave time for maternity, adoption, or caring for ill family members if the business has more than 50 employees. So to go a little bit more into OSHA, again, Occupational Safety and Health Administration, they write and enforce standards for health and safety in the workplace. Their job is to protect us as employees, not so much our patients, but the workers themselves. So they cover 4 general areas: general industry, maritime, construction, and agriculture. Dentistry falls under the general industry area of OSHA. Priorities of workplace inspection. So OSHA is going to come in and their main focus is going to be on imminent danger situations, any situation that is putting employees at risk, severe injuries or illness. A company or business has to report if there is any severe injuries, like someone's hand gets cut off, deaths, if someone is very sick from something that occurred at work. Formal employee complaints, referrals of hazards from other agencies, individuals, and even the media. targeted inspections. OSHA will often come in, especially to dental offices. They come into dental offices all the time. If something is not up to OSHA standards, they may put a fine that the office has to pay, and oftentimes it's a lot of money, like $100,000, $60,000. Like, it's a pretty hefty fine. And then if they do have an inspection and something is wrong, they'll oftentimes do a follow-up inspection as well. Let's chat about right to know laws. So the right to know law is a state law that allows employees access to information about any toxic or hazardous substances at their workplace, employer duties, so what their duties are, and their rights as well as an employee, and any other health and safety issues. The biggest part here, though, is those hazardous substances. They have to know where they are, what they're used for, how to use them, how to properly dispose of them as well. Some OSHA health standards as well. So OSHA does have a bloodborne pathogen standard that it's a set of standards that protects you as an employee from any blood or bodily fluid exposures to help protect yourself. The hazard communication standard, which deals with hazardous chemicals in the workplace. Chemical hygiene plan, ionizing radiation standard, so X-rays, exit route standard as well, and electrical standards. Medical Waste Tracking Act. So this says that OSHA may inspect hazardous medical waste and will cite facilities for violations. You can't just throw your hazardous waste into the dumpster out back. A lot of times a special company has to come in to dispose of it properly. Most often it is incinerated somewhere at a special place for medical waste. All hazardous materials must be disposed of in a safe and healthy manner. And you also have to provide training on what is medical waste and how to properly dispose of it. CDC guidelines. I'm sure we're all familiar with CDC, but they just give out recommendations for healthcare professionals. So they say wear gloves, eye masks, gowns, and other protective equipment, PPE, when performing tasks that involve direct contact with blood and bodily fluids, which us as dental professionals need to do. It also recommends wearing PPE protective equipment when performing tasks that do not involve direct contact with blood, bodily fluids, or tissues in case of accidental exposures. So even if we're doing, taking, I don't know, just a picture of the patient, we should still be wearing masks and gloves just in case they may cough in our face or something along those lines. So we're not expecting any blood or bodily fluids to get in our way, but it could happen, so we should be prepared and wear PPE anyways. Clinical Laboratory Improvement Act. So this is a federal statute passed in 1988 that established minimum quality standards for all lab testing. It requires that laboratories obtain certification, pay some fees, and follow regulations concerning testing, personnel, inspections, test management, quality control, and quality assurance. So it doesn't necessarily involve dental labs. It's more so for hospital labs, but still good to know. So next we have workers' compensation. This is a form of employer insurance that pays benefits to workers who have been injured or disabled due to a work-related accident, illness, or injury. So the keyword here, work-related. It happened at work or was caused by work. So it provides medical treatment, temporary disability, permanent disability, death benefits to any survivors, like wife, children, and also rehabilitation benefits as well. Filing for unemployment benefits. So to file an unemployment claim, a claimant needs to have a social security card, declare that they are available and willing to accept work, a statement of the reason for leaving the job, and each state is slightly different, so you really have to look state by state to see their actual unemployment benefit claim process. Next, let's talk about interviews. So because of these federal and state laws against discrimination, when you're having an interview with an employer, they cannot ask you any questions regarding the following things. So race or color, religion, creed, gender, your family, marital status, what type of birth control you use, your age, your birth date, or even your birthplace, disabilities, arrest records, residency durations, national origins, any military experience or military discharge, or membership in organizations. These are things that they just simply cannot ask you about. I'm not saying they won't ask you about it, but it is illegal to ask you. So if you ever come across an employer who is asking any of these questions, I would just simply state that that's not an appropriate question for an interview. Um, and they may be offended by that, but on the other side of things, you should also be offended to be asked that, especially when it is illegal to do so. So that just may not be the right fit for you, and they may feel like you're not the right fit for them if you're not answering the question, and that's perfectly fine. We move on, we go to a different interview. So these are some interviewing guidelines if you yourself are the one conducting the interview. So you are trying to hire another employee. You should make a list of questions pertinent to the job description and stick to those questions. Don't ask them questions about, again, what we just previously talked about, their families or their age, things like that. You want to make a list of questions that have to do with the job that you want to hire them for. Don't rush the interview, but also don't allow it to drag on for an unreasonable amount of time. Remain objective and make sure you're listening to the candidate as well. Ask general questions that may be helpful in selecting the right candidate. So maybe scenarios about what they do in certain situations if they're faced with adversity or some kind of issue. And then end the interview on a positive note, and also inform the candidate of the decision that you make. If you would like to hire them, obviously you're going to let them know, but if you decide not to hire them, it's so beneficial and just a nice thing to do to let them know that unfortunately you decided to go in a different direction, and that's okay, but it's better to let them know so they're aware of that instead of them holding on for hope that they're still in the running. Next, surety bond. So this is a type of insurance that allows employers, if they are covered, to collect a specific amount of a bond if an employee embezzles or steals any business funds. So obviously something we hope we never have to deal with, but there's this type of insurance if you're in a field or some kind of business where an employee may be likely to embezzle funds. Background checks. So financial and criminal background checks may be conducted by employers, and a prospective or current employee must acknowledge that a check is to occur. So you can't just randomly do a background check. The person that you're doing the background check on needs to have consent for it. Now, when an employee is hired, they do have to have some employee paperwork that is kept on file or on record for the employee. These must include the employee's social security number, the number of exemptions that they claimed on their W-2 forms, their gross salary, any deductions for social security such as Medicare or federal, state, and local taxes, any other withholdings, and also their I-9 form. So W-2, we just briefly talked about that. That has to be kept in the employee records, especially the number of dependents. But an employer must provide an employee with the W-2 form by January 31st of each year. The W-2 shows the following information: the employer's tax ID number, the employee's social security number, the total taxable earnings paid by the employer, and amounts deducted for income tax and social security, and also amount of advanced earned income credit payment, if any. So this is then what is given to the employee to use to file taxes each year.